Welcome, everyone. My name is Dave Relling, and I'm your Vice President of the Federation of State Boards of Physical Therapy Board of Directors. This year, the Federation is taking what we learned in 2020 to increase our engagement with membership through a variety of resources. We are expanding our educational lineup to include multiple monthly sessions. Each month in the webinar series, presenters address contemporary issues for regulators. The most recent topics include exploring unconscious bias, promoting prevention through practice advice, and trauma's impact on boundary violation investigations. We also have regulatory hours with Dale Atkinson, like today. Dale focuses on a regulatory topic and answers your most pressing questions. Regulatory training for board members and board staff will be conducted virtually from May 6th through the 8th this year, and registration is still open. There are more programs to be arranged this year, so please stay connected with us. The Federation of State Boards of Physical Therapy Board recognizes the challenges of being in a virtual world, but we want to hear from you, understand the challenges that you are facing, and how we can help as FSBPT. If there is anything I can do for you to help you get in touch with the appropriate board member or staff member, please feel free to reach out to me. Today, we are excited to have Dale Atkinson back for another session of the Regulatory Hour. Dale received his law degree from Northwestern School of Law and is the sole managing member of the firm Atkinson & Atkinson in Northbrook, Illinois. He was executive director of FARB for over 20 years and regularly provides educational sessions for regulatory boards and staff. Today's topic is Don't Stop Us Now, We're on a Roll, Rolls and Hats. Questions can be submitted in the chat function during Dale's presentation. He will address the questions at different times throughout the presentation. Please join me in welcoming Dale. Dale?
Thank you, Dave, and thank you to FSBPT and its board of directors for, one, putting on these seminars, and two, obviously allowing me to be involved in that. So I certainly appreciate that, and send my thanks, Dave, to the rest of the board of directors. I'd also like to, in particular, thank the staff that helped put all this together. So there's a lot of behind the scenes work that's done. So Bill, Rich, Caitlin, again, many, many thanks for what you do to help bring these together and help me at least be able to project to an audience. And the biggest thanks goes to everybody who's on the line today. Whether you're a board member, an administrator, executive director, inspector, assistant attorney general, or anyone else, staff person involved at a board level, anyone else involved in regulation of the professions, you deserve a big thanks. You're not thanked enough, and it's somewhat of a thankless job. But I do like to always take the time when I begin a presentation and end a presentation to, with all sincerity, reach out and say thank you to everyone that's involved in the regulatory community. As mentioned, we are going to talk about roles today, and roles can be very broad. It could be limited to an individual role who serves on a board, a state or provincial board, but it also can be broad and beyond that. And so we'll cover probably a lot of ground here today, and I will end the session with talking about 5 or 6 cases that will help illustrate some of the issues I think that we will discuss as we go. So welcome and thank you for being here. As we get started here, and to make sure you all are listening, go ahead and in the chat room, just type in the corresponding number to how you feel right now regarding these sheep that you see on the screen. So you can be a 1 right through the 9 there. So just make sure that I know that people are listening, paying attention. And I see we already have a 9 up that's coming up here as well. There may be a few 4s here, and sometimes I feel like a 4 as well. And but we will try to remove the buckets from our heads and talk about this. So thank you for participating. We try to have a little bit of fun here. And although we are virtual, I think we can be just as productive as if we were in the same room itself. As is customary, I'll start out with introducing myself a little bit with a celebrity lawyer, and then we'll probably do one more quick chat box participation by you folks. So that's not really me, but just to tell you a little bit about what I do in more detail. And the only reason I spend a little bit of time on what I do is to make sure you, those are on the line, realize that you're not alone as a regulator. You have your interstate or intrastate boards that you can deal with, whether you're an exec or a board member. You have interstate boards you can deal with and learn from. You have FSBPT that facilitates bringing you all together. and you have other boards in other professions. And so, the first thing I'll say is, as far as your role goes as a regulatory body, as a board itself within a state or a province, is to meet with other boards. Your role can be to assess the issues that do come up. So I do recommend that you meet regularly with other boards that may have relevance to your community. So um, um, whether it's physical therapy work on animals and the involvement of the veterinary board, whether it's dealing with issues with mental health, and so social work boards meet with psychology boards, meet with marriage and family therapy boards. So these are just tips that you can all learn from each other, realize you're not alone, and certainly realize that FSBPT is there to help you. As part of my practice, I represent a host of FSBPT-like organizations who are not-for-profit organizations whose members are comprised solely of the regulatory boards from the states and provinces, and with some groups worldwide as well. So I work with not only with you all in physical therapy, but social work, optometry, massage therapy, veterinary medicine, chiropractic, funeral director, embalmers. And I do a lot of work with some local folks here in the Chicago area on a pro bono basis to assist with some of the regulatory issues that do arise. So a little bit about me, a little bit about perspectives, but much more about bringing you all to the table and ensuring that you understand you have others that you can rely upon and learn from. So quickly back to the chats, just type in your favorite sport. And again, we'll get going eventually. I promise we will talk about a little bit of content here, but if you want to put your sport in there. And to give you a little bit of bias, just one more fun fact about myself, there's really only one sport that exists on Earth, and that's it right there. It's hockey. So if somebody puts hockey in there, Frank, you get some bonus points for being here today. I see a hockey popping up here a couple times. So this is just to get you guys warmed up, to ensure that you know you can be involved, type in a question, and make sure that if need be, we can interrupt ourselves and try to answer those. The last little introductory comments I'll make is about terminology. I'm going to use the word license probably a lot. I might say state a lot, but this is with all due respect to registrations, certifications, with all due respect to provinces, territories, districts, commonwealths, and everything else. But you all absorb what we talk about into your worlds specific to your jurisdictions, and then figure it all out. But again, I will resort to words that I'm used to using, but it is certainly with all due respect to everybody on the line, no matter where you are from. As mentioned, we're doing these on a monthly basis. We talked about let's meet with and for a purpose, which we discussed the purpose of regulation. Next, we talked about how do regulators meet these obligations. Today is Don't Stop Us Now. We're on a roll, and the rest of the year are set forth there. So I look forward to seeing everybody on a monthly basis if possible. Now, to get an idea of you all as the audience, and we couldn't poll the audience with this many factors, so I did it my way. And just, if you want to type into the chat the numbers that correspond to the roles that you play, and there may be more than one. So if you are a licensee, you belong to the state chapter, the national chapter, you're on the board, you may be on the board of directors of FSBPT, you may have any other roles that we can think of, you could be an attorney or otherwise. So feel free to put some of those in there. And the more numbers we see, the more we realize that this discussion about roles can be very important. And separating those roles where necessary, allowing them to merge where necessary. It's not always a separation, but most of the time it will be. And if we're talking about separating roles, it's likely we're heading toward a potential legal issue or a potential issue that could inhibit or stymie the board's ability to carry out its intent, carry out its function of regulation in the interest of public protection. So it's worthy of, as you read these, and I see lots of numbers coming up, it's worthy as you read these that you start to think about these roles and how they come into play and when they come into play and how important it might be. Now, understanding a regulatory role to me is a mindset. It's something that we're not used to thinking about. It's something that many of you are thrust into by either an appointment or, if you're in a Canadian province, an elective process. And you are now all of a sudden sitting in a board chair that would be a state board, and you're asked to carry out the functions of that board itself. You're used to being a licensee. You're probably used to being an advocate. You may be involved in advocacy issues, lobbying issues. You may be involved in promotion of the profession itself through the trade association, through national chapters, state chapters, or even local chapters. And this mindset and this change is something I spend a lot of time on with my clients. I do a lot of board member training. And as mentioned, FSPPT's board training is coming up early next month. So check on their website and see if you're interested in attending. But much of what my role is in these trainings that I do for my clients is to separate these roles that you may have at the same time. In particular, separating trade from regulation because of the legal and practical issues that arise out of it. We'll use some examples a little bit later, but the short version is, as these roles merge together, perhaps improperly, is when we start to see, one, legal issues arise, litigation filed, and political activity. So, hey, let's deregulate because of certain issues. Hey, let's lessen the number of licensees on the board and increase the number of public members on the board, or at all points in between that you all can think about. And many of you are probably in the midst of addressing some of these issues, or at least keeping your eye on these issues from the regulatory community perspective. So it is a mindset. It is something that the more you hear, the better off you are. And it's something we spend a lot of time on. So as I've mentioned, and I'll emphasize this now a little bit more, is separating trade from regulation. So the fact that you are a licensee and you would like to see the profession flourish is fine. That's something that is customary to those that are working in their professions. Once you are moved over into the regulation side, the board side, the state or provincial board side, that mindset has to change. It has to change. But you all have to understand, why do we populate boards with licensees? Everybody should know the answer to that. And the short answer is, we need the expertise so the board can function efficiently. And that expertise is necessary to, one, interpret the statute. So a scope of practice is written by the legislature, and you all interpret that using the expertise you bring to the table without promoting the profession. The other reason is you're promulgating regulations that are adding specificity to the skeletal statute that should exist. Legislators should not be in the business of enacting laws that are so specific to the professions, because they don't have the expertise. You bring that expertise to the table, coupled with public or consumer members as defined, and then you carry out excuse me, the intent of that legislation using that expertise. And what does that create? It creates an efficient system that allows it to move forward in a manner that, again, takes care of regulation much more efficiently than a criminal or civil setting that we're used to seeing on a legal basis. So understanding that role that you play, the mindset we've talked about, and keeping trade promotional issues out of the factors that you consider once you serve on the board. If you're unable to separate those two, that's fine. There's nothing wrong with that, but you may be better off not serving in regulation and serving the trade organization. That's okay too. But when they come together, we do see issues and legal issues and practical issues that arise. So the question that was being asked, and this probably has been, I've been asked this question for years, but was really focused upon, is during the North Carolina State Board of Dental Examiners case. But can boards be trusted? Can boards who are made up primarily of licensees within the profession be trusted to regulate that profession in the interest of consumers or the public? We all would answer that question definitively with a yes, a resounding yes, but is that really how it works? And that North Carolina State Board of Dental Examiners case allowed these issues to surface more, for the good and perhaps for the bad, but you all were identified as active market participants by the United States Supreme Court. And that active market participants is really just calling you a licensee by another name, and ensuring that you are carrying out the intent of the legislation rather than promoting the profession itself. So the bottom line of that case, which, as you all probably recall, and you've heard a lot about it, I'm sure, over the years, It was a case under the antitrust laws to say, is the profession itself regulating in a manner that might be anti-competitive and keeping people out of the profession, or dictating who gets into the profession in an unlawful manner? And the Supreme Court here said that, and again, a quick recap of this, it's important to understand this for purposes of our role, is in that top line there, a non-sovereign actor, which, by the way, to this day, I'm not exactly sure what the US Supreme Court, why they call a board, a regulatory board, a non-sovereign actor, but controlled by active market participants enjoys immunity only if the challenged conduct is actively supervised by the state. That's where the case focused. And at the bottom there in the red, the need for supervision turns not on formal designation given by states to regulators, but on the risk that active market participants, that's regulators who are licensees, will pursue private interests in restraining trade. Fancy language, but it's all talking about separating trade from regulation, ensuring you understand what role you are playing when you serve on a regulatory board. And that serving on a board, by the way, can be a board member, can be a staff member, executive director, administrator, could be an assistant attorney general. It could be a departmentalized bureaucracy that some states have. So it is more than just an individual board member role. It's certainly all others involved in that process. Now, we did cover the purpose of government, and so the role of government, I want to just go through a few slides here relatively quickly that address the roles that each of these categories that I've identified play in that role of government. And when we talked about this in February during the regulatory hour, we focused on issues related to the statutes and even the Constitution. So I pulled from the U.S. Constitution what I think are important words: form, establish, ensure, provide, promote, secure. These are good words to define what it is government does. Forms a more perfect union, establishes justice, ensures domestic tranquility, provides for the common defense, promotes the general welfare, and secures the blessings of liberty to ourselves and our posterity. So these are ways that we all, as regulators, can start to formulate in our own way how to articulate the role we play, what it is boards do, and why government is even involved in the first place. And as mentioned, I do a lot of training, and we spend a lot of time on some of these issues because I believe they're glossed over. These roles are really not identified because you dive in, you're appointed to the board or elected, you come to that first board meeting, there may be a contested hearing at stake, and all of a sudden you're in the midst of trying to make decisions based upon evidence and legal issues and the statutes themselves. And we don't necessarily step back and say, what is it that we're really trying to accomplish? So that leads to kind of take home point number 2, and that is you all should be having strategic planning at the board level. It's a public meeting, sure, notice it up, but do strategic planning. Think about what your mission is, what your vision is, what your website says, and how you might then carry that forth. It's certainly a good exercise to ensure that you understand the role of the board itself, but secondly, how it is being articulated to the outside world. And go read your website for each of your boards itself. I do that a lot. And many boards don't have a mission statement. They don't have a vision. They haven't necessarily talked about this because they're too busy dealing with, and this isn't necessarily a bad thing, this is reality. They're too busy dealing with the nuts and bolts of what it takes to run the board itself and have those meetings. Take a step back and exhale and figure out the role of government and the role of your board itself, why it exists. So if we can go to this first poll here, and Caitlin is going to help us with that. So a poll is going to pop up. You're going to have the right now to vote. You have the authority here as an attendee. So what is the role of a physical therapy board? Promote the profession, generate revenue, enforce the Practice Act, lobby the legislature, all of the above. And so as I chat, we're giving you time to digest this and think about this. And there's no one will be held accountable for your answers. We don't know who's answering in what way necessarily, but it's a good exercise for, I think, all of us to step back and think about this. And so as we can see here, most of you are saying enforce the Practice Act. That's a pretty obvious answer. And so Theoretically, I would think most of you would gravitate to that particular response. This multiple choice approach, by the way, has not been validated like an exam program. And by the way, you all can be chuckling when I say these things are intended to be funny. But we can go ahead and end that. But you can go ahead and share the results now. And maybe I was only seeing the results for now. So if Caitlin, you want to share those results. So you can see most of you answered that Enforce the Practice Act. A pretty obvious answer. A few of us said all the above. And, we could debate what is most important about these. But for those of you who might think promoting the profession is one of the roles that a regulatory board plays, this is the North Carolina State Board of Dental case. That's where they really were, I think, promoting the profession and trying to ensure that, one, people were kept out of certain aspects of dentistry, and two is, I think, probably to raise up the revenue generated on behalf of licensees who are in the business of providing dental services. So we want to be a little bit careful about promoting the profession as one of the issues that we might say a regulatory board does. It probably does not, but I do realize that certain enforcement of the Practice Act and others might elevate that profession to a status that is recognized by consumers because government is controlling the business by issuing licenses and allowing people to practice and prohibiting others from practicing. So I get that, but this is a mindset. This is a matter of how do we articulate that. So if you want to end this poll, and I will carry on then as well. I'm still seeing it, but maybe I need to, there we go. All right, thank you. So keep that in mind, the role of the board, how you articulate that, okay? So the short version to me is, if I'm asked, I'm on a regulatory board, what does the board do? What's the role of the regulatory board? Hey, I can answer that in a very short sentence: carry out the intent of the legislature. That's never a wrong answer. And if you're talking to a policymaker, an elected official, a politician, this is how you defer to the legislature, which has created and authorized you to act. It has created you as a board and delegated to you the authority to enforce the Practice Act. So what your job is, we carry out the intent of the legislature. That intent is not always obvious. It could be, there could be ambiguous language in the statute that you, as the experts we've already talked about, interpret. And as mentioned, you promulgate regulations to assist you as a board to help fulfill the intent of the legislature. So the role of the board is to carry out the intent of the legislature. And that's a good, short, succinct way to say what it is that boards do in that role, that important role. Now, what role does the staff play, the executive director, administrator, and other staff undertaking the day-to-day operations and assisting the board in fulfilling its mission by convening the board, allowing the board to convene, and creating the avenues by which that you can meet as a board itself? And we understand that in the COVID world, your meetings have probably changed from perhaps face-to-face to virtual meetings. That, I'm asked this question a lot, and that is one thing I think that will stay post-COVID, and that is virtual board meetings. It's quite efficient. It's probably way less costly for the state, and it provides people the ability, board members and staff, to attend without having to perhaps travel long distances and be inconvenienced more. And so fulfilling that obligation of the board itself and the mission through meeting is one of those aspects. You may be able to meet more often, but for less hours, and become more efficient. So that's the role. It's pretty straightforward there. That staff plays is to ensure that the board carries out those missions. So let's quickly talk about the role of the board attorney. And let me move my picture here so I can see my slide a little better. The role of the board attorney: provide legal advice and historical perspective. And I realize that many of your boards have perhaps more of a revolving door of attorneys who represent the board. So you may not have as much historical perspective as you would like from the attorney who represents the board. However, the Attorney General's office, assuming the Attorney General their office does represent the board itself, will have that historical perspective. So hopefully you get consistent advice and historical perspective related to that. Now, your lawyers protect the interests of the board itself, which includes you individually as a board member, includes the board as a whole, and it certainly includes protecting the interests of the state. Now, lawyers who represent boards may be in dual roles as well, and we're going to see a case coming up soon that identifies those dual roles and how it may come back to be problematic for that lawyer. So understand that. Now at the top of the slide, you can see, remember that attorneys work for boards, boards don't work for attorneys, that you are their client and you're entitled to question the attorney's advice. You're entitled to ask for additional opinion. You're entitled, likely if you have to move up the chain and assure that you are carrying out the intent of the legislation, and that the legal advice you receive is providing you with a basis to do that. So don't be bashful about challenging your lawyer and the advice you may be getting if need be. It doesn't mean you challenge just for the sake of challenging, but it certainly can mean that you can ask questions and ensure you understand the advice that you're getting. So understand those roles and understand your roles as a board in dealing with consultant, advisor, attorney, and that could be for other reasons as well, consultants, whether it's computer programming or accounting or anything else. So I spent a little bit of time early on talking about the FSBPTs of the world and their role. And my short version of most all of my clients is they provide programs and services to their member boards, state and provincial boards, to lessen burdens on state government and to promote uniformity. And so the licensure exam is a perfect example. Most of my clients develop, administer, score, and maintain uniform licensure exam programs. And they do so using industry standards and others so that those examinations are validated psychometrically or statistically to ensure their defensibility in the event of a challenge. Imagine if every state had their own exam. And I've been at this long enough, and this is my 33rd year of representing groups like FSBPT, where I can remember where the exam programs were not necessarily used by all jurisdictions, and there were different exams out there that states were using, that the member boards were using. This uniformity is super important to understand and the role that can be played. If an exam can be validated nationwide or perhaps North American wide or perhaps even internationally, the benefits that has to assessing entry-level competence and how it can save you, the state boards, from having to develop your own program, which by the way is difficult, it's expensive, and it does not promote that kind of uniformity that we need right now as a society, especially based upon technological advances. So you can read the mission statement of FSBPT, but understand their role and how they can help you through the provision of programs, the development of programs, and how you can stimulate FSBPT to take on or at least explore initiatives that you think may be beneficial to the regulatory community as a whole, to the physical therapy regulatory community as a whole. So understand that role and be active and participate in the FSBPT meetings and others. And actually these seminars, or these regulatory hours, I guess we should call them, are another aspect of that. So if we want to run the next poll now, and the question right here is what role, let me move that so I can read it. What is the role of the National Physical Therapy Examination? So you can establish advanced standing. Is it a capstone to assess the academic programs? Does it establish entry-level competence? Does it limit the number of people who can become licensed physical therapists? So once again, maybe the answer jumps off the page at you, and that's good, but these are discussions worthy of having. And for those of you on the line, think about this questions like this, and this is probably a pretty good example. How would your fellow board members who may not have been quite as active in attending regulatory hours like this, attending board training, either at the jurisdictional level or through FSBPT, who maybe are new to your boards, how would they answer this question? Do they know enough about this? So I encourage you, as the veterans who are receiving this kind of training, this kind of discussion, to ensure that fellow board members back at your each of your specific jurisdictions understand these roles, and that they do participate, and that you can promote whatever, a regulatory hour, a board member training, an annual meeting of FSBPT, whatever it is, so that people walk away from this understanding their roles. So did you share the results, Caitlin? I think you may have. But if not, go ahead and share those results. You can see it's unanimous. Everybody used that entry-level competence as their answer. Certainly good to know that people understand that. But I think you'd be surprised if we asked this question of all regulators in physical therapy of all jurisdictions, how we might get some varied answers. So good that everybody understands and knows that, and we can carry on to the next slide. So next poll question. Is physical therapy self-regulated? Simple yes or no. And I'm watching the answers populate. Seems like maybe there is more of a variety of answers on this one. So think about this a little bit. Is it self-regulated? Think about the dental board case and think about the issues that came up with that. And think about populating boards with licensees. Think about how government is involved and others. So we have pretty much, and you can go ahead and share these results. You can end it and share the results. So it's about a 50-50 split here. This is an issue that is very much worthy of having a debate about. Having a discussion is probably a better word. Having a discussion about this and ensuring that we understand as regulators perhaps how we might answer this question. And I will say this, that the Canadian provinces may have a little bit different answer than the US jurisdictions. So just to give you a different role and different perspectives, but whoops, I thought I had a slide with that. My answer to this question is a definitive no. It's not self-regulated. And if it were self-regulated, if your profession, and I shouldn't call it your, if the profession is self-regulated, then you don't need government. That's my short answer to this question. I can understand why some might answer this yes, and as I've mentioned, we could have a nice discussion about it. But in short, I would say no to this. I would want to avoid anything along the lines of the dental board case, anything along the lines of antitrust allegations or others. Keeping in mind that because this question and because of the dental board case, this is why, as I've already mentioned, legislators are considering diminishing the number of licensees and increasing the number of public members. Is that a good thing? Is that a bad thing? You all think about that. There's no good or bad necessarily definitive answer to it. But as we increase consumer members and decrease the experts that are needed to weigh this, the system becomes significantly less efficient because those roles start changing. And because the people who are sitting in the roles of making decisions don't necessarily have that expertise. And now we end up maybe turning an administrative system, which is where you all live, into a civil system. And civil systems, you probably all know, are not very efficient. We convene a jury to make a decision, and that jury at the start has no idea perhaps what the issues are or what the technicalities of the discussions might be about. So you convene a jury, and Apple and Microsoft have a giant lawsuit over patents. Believe me, those jurors don't know anything about patents when the litigation starts. So what has to happen? The lawyers, through witnesses, have to educate the jury on the standard and how that was perhaps breached. That creates a system that is not as efficient as an administrative system. So keep that in mind as you think about roles, keep that in mind as you talk about self-regulation, and certainly keep that in mind as you determine what it is you can bring to the table as a regulator. So let's make some of these points through some case review issues. Now, I'm going to go through these cases quickly. The facts of them I will go through quickly, and we'll focus a little bit on the outcomes because the facts are not all that important necessarily. And when they are important, we'll try to emphasize that. But keep in mind, most all of these cases and most all issues related to roles, where the role is being questioned and there's perhaps a conflict at stake, it's a question about due process. Okay. And most all issues related to challenges to roles played will be couched in terms of constitutional due process. The system was not fair to me for the following reasons. And everybody, all you really need to know on this line today about due process is fairness. That's the short version for you guys for due process. Let the lawyers take it from there and figure out, how due process comes into play. Is this fair? This person, the respondent, the licensee who's under challenge, didn't have adequate notice of the charges. That's probably not a fair process. You all can figure that out, and lawyers can debate about it in legal technical terms. But generally, it's going to be about due process, which is a Fifth Amendment issue under the US Constitution, and it's applied to the states under the 14th Amendment. So you see a lot of fancy stuff coming out of that, but it's really pretty straightforward that the interest you have in a license is a property interest, okay? It's issued by government, and it has consequences to not having that license. In other words, in order for me to lawfully practice physical therapy, I need to be issued a license by government. This, by the way, is why it's not self-regulated. Another reason. So the license is issued under a process whereby I establish the statutory criteria: education, exam, experience, good moral character, file the application, pay a fee, whatever it is. If I comply with everything, that license is issued. I am now able to lawfully practice. Okay. And now before you can take that property interest and license away from me, you've got to give me due process of law. Due process in your guys' world is pretty straightforward. Notice of the charges and an opportunity to be heard. And by the way, that does not necessarily mean in-person hearing. Perhaps, it depends. But notice, opportunity to be heard before a fair and impartial tribunal. The decision makers have to be unbiased. And in the end, if you follow those three simple rules, it's likely you won't have a due process type challenge that like we're about to see. Now, one of my favorite cases, and I talked about this case for years back when it first came out in the late 1980s, and as it matriculated through back and forth. This case is super complicated. It went up and down in Louisiana multiple times, and eventually did go to the Supreme Court of Louisiana for ultimate decision. But a little bit of background about this case is a dentist who's under administrative prosecution. I'm going to call it prosecution. That's a heavy word. That might sound criminal, but it's an administrative prosecution. Complaints against his license. He's entitled to notice. Investigations have, negotiations happen. If there's no resolution, you go to a formal hearing. Okay. Now, the prosecuting attorney who worked for the board, who prosecutes via the Attorney General's office, interviewed witnesses and said to these witnesses who were former employees of the dentist, if we had certain information, this would help the case. And they talked about it, et cetera. So what happened is two employees who were subject to being deposed, so they were asked a lot of questions as the investigation occurred. They're former employees of the licensee. They went back to the office and they broke into the office at night and they stole a bunch of incriminating material and they gave it to the prosecution team, administrative prosecution team. So a side issue in this case was, can you use that information? Is that fair to use that? And ultimately the Supreme Court said, yes, you can, because the state did not tell them to go do that. The attorney for the board, Assistant Attorney General, did not engage in any activity that incited them to go do that. So ultimately, they were allowed to use this. Now, so let's take a look at some of these bullet points. The dentist was administratively prosecuted. He was sanctioned with a 10-year suspension and 10 more years of probation. The first thing that you learn about this case, and it's not necessarily about a role per se, is 10-year suspension, and differentiate that from revocation. Okay, I'm a big fan of suspensions because it keeps that licensee under the jurisdiction of the board. They have a license that's under suspension. You revoke it, they would argue you no longer have any say over what I do or not do, and I may continue to practice. We have an unlicensed practice question and others. But so you may have the authority as a regulatory board to assess a longer suspension. Okay, there were some costs and fines imposed upon this as well. Now, during the pendency of these administrative proceedings and all the investigations and the up and down that was happening, the respondent, the dentist, filed a lawsuit in federal court against the board, arguing civil rights violations and all that. Under legal doctrines, that case will be stayed until the administrative proceedings are finalized, because it's hard to say were any rights violated because you're not done yet. So that's what happened here. But what this wise dentist, perhaps wise lawyer for the dentist, then argued was that the entire board has to be recused because they're biased, because there's a pending federal lawsuit, which is just waiting in the wings. It's being stayed pending the outcome of the administrative proceedings. So we might call this lawyer smart. It didn't work. That was denied, the recusal issues, but that's a role issue. That's a conflict issue that may come up. But what happened next is where it got troublesome for the Louisiana board, the dental board in Louisiana. And that is, once the administrative proceeding was over, the prosecuting attorney who represented the board also went into the deliberations and helped draft the findings of fact and conclusion of law. He did so under the direction of the board. So theoretically, an argument could be made that he didn't introduce his thoughts into it. But the question now became the role of the lawyer. Can you be a prosecutor and an adjudicator at the same time? Well, the Supreme Court said, no, you cannot. And that lawyer's involvement in helping draft the findings of fact and conclusions of law it tainted the process. It violated due process. It didn't separate prosecution from adjudication, and they reversed and remanded this back down. So as I mentioned, this is a complicated case. It went up and down a whole bunch. A lot of interesting facts came out of it. I was going to say fun facts, probably not fun for Dr. Allen, but maybe fun now to talk about this many years later. But we can learn a whole lot from this case. This particular case, it is still good law. This next case is out of New Jersey. It involves the recusal of 2 board members, conflict of interest bases. Now, one recusal was due to a staff person who denied a building permit, okay, as a staff person, who then later became a member of the board, but was also going to now appear as a witness. So we've got a little complicated fact pattern here. Previous role as staff, did his job, now became a part of the board, recused, but now is going to be a witness. So an argument plausibly could be made that this witness is going to unfairly prejudice the system here to the detriment of the respondent. A bunch of continuances were granted in this case, and many of those continuances were because, based upon the 2 recusals, they could not get 5 board members to the table to hear the matter and ultimately make a decision. And so this is a good issue of recusals. Does that create vacancy? Vacancy is not a good word. Does that create a new calculation of the quorum and when a board can and cannot act? And how do you calculate? If you have an 8-person board, and so you need 5 people there to establish a quorum to undertake business, okay? Straightforward. If you have an 8-person board and 2 recuse themselves, do you need 4, or do you still need 5 because of the total number of board members is 8? So ask yourself that question. There's no necessarily right answer for that one. I would suggest the answer is 4, but your lawyers may have a differing opinion, and which, by the way, follow the advice of your lawyers. So you can listen to me, but obviously take this back and follow the advice of your lawyers. So here, the chairperson of the board eventually unilaterally transferred this matter to another board in another township. And in construction, contractors, they can regulate at the state level, they can regulate at the county level, they can regulate at the municipality and others. So there are a lot of townships that may actually hear matters like this. The original township involved in this appealed the matter. Again, because the board and the township were different entities. The long and short of this is the court reversed it and said you can't unilaterally transfer this to another township. They didn't have jurisdiction to hear it. So it needs to be heard back in the original one. And now we have to overcome this 5-person board issue eventually. So we can see 1, recusals here, and 2, the consequences of those recusals that might exist. We got to get a law case in here as well. Graves versus State Board of Law Examiners. This is a case out of North Dakota. An applicant to the bar was initially notified that they were given a conditional admission to the bar to get their license. They were going to be on probation. They had to have a mentor, prohibited from operating as sole practitioner because of activities in a beekeeping business that this person was involved with their father-in-law, and they had some disputes, and there were some allegations of wrongdoing by the now wannabe lawyer. Eventually, the applicant requested a hearing because said this applicant didn't want to agree to these conditions for this. And in the midst of all this, the applicant learned that the board chairperson was married to a beekeeper. And that beekeeper had an acrimonious relationship with the stepfather with whom this applicant had their dispute. And that sought disqualification of that board chairperson based upon the fact that she's married to a person who may create this conflict. And the North Dakota Supreme Court eventually agreed and remanded the matter, saying this applicant is entitled to due process, and that chairperson should not be involved in the ultimate decision making. So that gets to, remember everybody, due process, right to notice, right to be heard before a fair and impartial tribunal. They couldn't meet that 3rd prong of a fair and impartial tribunal. And I learned in the midst of this, by the way, that beekeeping is an extremely large industry in the state of North Dakota. So I guess there's a lot at stake here related to that. So let's think about now the role of the board in its rulemaking process vis-a-vis the role of the legislature. Everybody on the line today should know that boards promulgate rules that add specificity to the statute. Legislatures enact laws that should be general in nature because they don't have the kind of expertise. We've talked about that. So the board here in Texas promulgated a rule defining the foot. The podiatric board promulgated a rule defining the foot, and that definition was very broad, and it could have been interpreted to actually encompass much of the lower body of a human being. The trade associations for both orthopedic and medical filed a lawsuit arguing that this is outside the scope of the authority of the board itself because it expanded the scope of practice. And we all need to know that expanding the scope of practice is a legislative endeavor, not a board. You cannot expand a scope of practice through the promulgation of regulations. You perhaps could interpret an already written scope in a certain manner, but you cannot technically expand that scope. That is reserved for the legislature. The lower court in this case found the rule to be valid, and it was reversed on appeal. Say it's not valid. It did expand the scope, and they held that the rule was not in harmony with the general objectives of the statute, and thus the board exceeded its authority. So what's the role of the board in promulgating regs? You act within the scope of that authority. And in this particular case, you're acting within the bounds of the scope that had already been written, and you could not expand that through the promulgation of rules. And in your guys' world, I think you all talk about dry needling a lot and others, and so that would be a good example of, can you address a certain scope and identify through rules that physical therapists can or perhaps cannot do certain things. So you all can think about that and digest that. This next case is dealing with not promulgation of rule, but a policy. So you all ought to understand that there are statutes enacted by the legislature. There are rules promulgated by the board. Both of those have force of law. And then there are policies that are adopted by the boards. Those are generally more operational. In this particular case, the New Hampshire board adopted a position statement permitting certified registered nurse anesthetists to use nurse anesthesiologist. those are words I can't say very well, and certified nurse anesthesiologist as descriptors in their title. The Trade Association for Human Medicine and the New Hampshire Society of Anesthesiologists they challenged this. Can they do this? Because to call someone an anesthesiologist is within the practice of medicine. You need to have a license as a physician in order to do that. And eventually, the Supreme Court of New Hampshire ruled that the policy of the New Hampshire Board of Nursing exceeded its scope, and that the Board of Medicine had the exclusive, if you will, authority dealing with those that can call themselves anesthesiologists. So this is this is a title case. Who can call themselves what? It didn't change the scope, but it certainly did address issues related to what you can call yourself and how it may be misleading to the public. Secondly, important about this is we're dealing with a policy now. And to me, if I were asked this question, can the board do this through policy? The answer would have been no. You need to promulgate a rule if you're going to do this, because it's of general application across the board to potentially many licensees, if not all. So that would be one of the questions that come out of this, but understanding that role, understanding what it is that you can and cannot do. This next case is a rulemaking case. The Florida Board of Professional Engineering promulgated a rule defining engineering survey. And that included and encompassed what land surveyors do. You can see the fight coming now. And anytime, to me, you see fights like this coming up, nobody's going to win this case. In fact, in the end, it's just turf battles that are going on, being done via the regulatory board itself. That's not a wise move. Courts don't like that. Policymakers, politicians, legislators don't like that. But here it is. And again, this case is older, but I use it as an example regularly. So it's from 1985. But it's a Florida case. And as I mentioned, they promulgated a rule defining engineering survey. And the land surveyors argued that it exceeded their authority because there's no statutory authority for granted for general rulemaking. It's kind of a technical case as to how do we define rulemaking. The hearing officer concluded the board had exceeded its authority, but the Court of Appeals reversed and find that they were authorized to promulgate the rule and that there was no legislative intent to limit land surveying to only licensed land surveyors. So think about dry needling or anything else. Is that limited to one profession? How might you articulate that? But you're going to do it via the scope of practice. Anytime any board argues we are the only board that can do this, we licensees are the only people can do this, it's going to raise some red flags. So we have to embrace the overlapping scope issue when it comes to understanding our practice acts. A couple more cases. This might be the last one. This is a medical board case dealing with revocation of licensure. I've already talked about in the Allen case, 10-year suspension versus revocation. Suspension, you may remain under the authority of the board. Revocation, you may not, or an argument could be made that you've divested yourself of that kind of authority. So think about that. That's just a little side note. The respondent argued bias on the part of a panel member here related to the administrative prosecution, and the court rejected that argument. And I put a couple quotes in here in the slides. I don't usually read quotes too often, but I like this quote, and I think it's worthwhile to spend just a minute on it. The court said the applicable due process standards, so for y'all, fairness, okay? The applicable due process standards for disqualification of administrative adjudicators, that would be you folks, who are ultimately the decision makers. And I realize some of you have hearing panels and others, but if you are the ultimate decision maker. So the standards for disqualification do not rise to the heights of those prescribed by judicial disqualification. The mere appearance of bias that might disqualify a judge will not disqualify an administrative board member. Moreover, there is a presumption that administrative board members acting in an adjudicative capacity are not biased. That's an important concept, that the presumption is that you're not biased and that the entity or party challenging it has to prove that you are biased. So it's a burden question, but the point is here is, and this is the right these are good words. We all should live by these, that you're presumed to be not biased, but for factors that indicate that you are. And it's up to the challenging party to show that, establish that. So the court continued to overcome the presumption, then that would be the presumption that you're not biased. The plaintiff must demonstrate actual bias rather than mere potential bias. And I do a lot of training where we talk about conflict questions, and the question always comes up, well, you know, gee, I know this person, I went to school with them, or what have you, do I need to recuse myself? You do not want to say the sky is falling here and recuse yourself every time you turn around, especially in a profession or a jurisdiction that has limited number of people or practitioners. You may know a lot of the practitioners. So bias, by the way, and conflict of interest is personal to you. So you digest the facts and you say to yourself, can I be objective? And if yes, then you stay in there and you do your job and you protect the public by enforcing the Practice Act. If you cannot be objective, then you recuse, and you do it on the record as soon as you know. And when you do it on the record, you don't need to give details. For purposes of objectivity, I'm recusing myself from this matter. That's all you need to do. It's in the record now. It's read in there, and you hightail it out of the room, by the way. You don't stay in the room. You don't make faces or sit in the back and say, no way, you can't do this. So, so understand how to recuse when that comes up. So now back to our quote here. So you must demonstrate actual bias rather than mere potential bias of the board member challenged, unless the circumstances indicate a probability of such bias too high to be constitutionally tolerated. I don't know what that means. That's going to be case by case, but this is just good language for us to learn from. So there may be a situation where potential bias could give rise to a recusal, but don't take that to the bank. That's not the rule. The rule is you're presumed to be not biased, and someone has to affirmatively show that you are. So when you understand your role individually, you're better off, I think, taking on these types of matters that do come up. So somebody type in a take-home point or two. I'll feel good that I did my job. My job is to provide you hopefully with take-home point or two. But I usually try to leave just the last few minutes. We're kind of right on time now. If anybody typed in a question that came up or a take-home point, I would read it out loud. I would be happy if you did that.
Dale, there was a question that came up a little bit earlier, so I'm going to
Okay.
read that to you if that's all right.
Sure.
Licensees often do not trust the board or college and feel the regulator is out to get them. How can regulators cultivate and maintain trust with those they regulate?
That's a good question. I think one of the things that I would suggest, and I do this on a regular basis, and that is encourage people to attend board meetings. Encourage people to understand what the board does, why it exists, and that you're good at it and that you take it seriously. And so maybe free CE to licensees. And the other thing too is if I were running an accrediting body that accredited schools and colleges or programs that lead to a degree and then ultimately to a license like yours, I would say you have to attend a board meeting before you graduate as part of a condition of graduation. They're not hard to attend. Nowadays, you're meeting virtually, so you can log in and watch the board meeting. And so I think educating both consumers, academia, and licensees about what boards do, it goes a long ways toward probably addressing your question here as well. And somebody typed in here, we're all public members with specific expertise, and some have particular expertise. I think that's a great way to put it, because I say that a lot. You're all public members. Some of you bring expertise to the table. So I like that point.
Just to follow up, Dale, on the last about trying to encourage people to attend meetings. Nancy Kirsch had put in there, that's one of her COVID rainbows, is just that the virtual meetings allow more people to attend. Are there any things that, and this might be outside of the roles part, but are there any things that boards should be concerned about or aware of before they start a virtual meeting?
Well, let's go with, I think, where I thought that question was going, and that is things to be aware of if you're inviting people to your meeting is make sure you sit up straight and you operate as you should. When you have a virtual meeting, there's a whole lot to be aware of. One is executive session. How do you ensure who's on the line and who's not on the line? Do you get off the line and reconvene in executive session? And the other thing is to ensure that you have the technology to mute and unmute when you have to, and people don't say the wrong thing, so to speak, at the wrong time, things of that nature. But other than that, to me, it's just like meeting in person. It's just like now, we could be sitting in a room. I could be saying the same thing. You might be more encouraged to ask a question rather than type it in or what have you. But I think it's pretty straightforward. But act accordingly, sit up straight, and hold your meetings in a somewhat of a formal setting, and encourage people to be there. So I think we are right at 4 o'clock. So Dave, thank you so much for hosting. FS BPT board and staff, thank you for what you do, but big thanks to everybody on the line today and for what you do for public protection and regulation of the profession. So thank you.
Thank you, Dale. And thank you everyone for joining us today. We hope that you were able to use today's topic to identify many of the roles each of us have and how they may influence our work as regulators. I want to remind you of upcoming sessions. For April 28th at 4 p.m. Eastern Time, Speaker Zubin Austin will present Who Do You Think You Are? The Impact of Professional Identity on Professional Practice. This session will be a collaborative session to understand how professional identity shapes clinical practice and day-to-day interactions with patients and colleagues. On May 27th, Alan Lee, Alice Bell, Heidi Kosakowski, and Michelle Sigmund Gaines will present on telehealth. And then our next regulatory hour with Dale is Wednesday, May 19th at 4 p.m. Eastern Time. Together is Better, Collective Wisdom and Voice for Jurisdictional Boards. And just one other comment before you all go, I just want to follow up with how Dale started and then ended his presentation. Where you're probably all feeling like me, a little unsettled. There are many things going on in the world, but I want to make sure all of you know that Federation of State Boards of Physical Therapy, me as a board member, the rest of the board of directors, the people that you protect in the public, we appreciate all that you do on a day-to-day basis, and what you do matters. And please continue to be a great regulator and provide that regulation to protect the public, because what each of you is doing is very important. And thank you so much for joining us today. I think that's the end of our session. Thank you all for being here, and have a great rest of your week.